Hello guys, today we gonna discuss some two important article from the Hindu, and today there are two articles which are important on the eighth page of today's paper. That is, one is toward a genetic panopticon and against the mandate for inclusion. These two articles are important. Let's get started with all that. The first article today towards genetic panopticon. The DNA bill right now in Lok Sabha, they passed a DNA bill. In that DNA bill, the state has given a lot power to collect the DNA data and without the permission of the man from whom they are collecting genetic material for the criminal cases and civil cases, any dispute related to resolve the dispute between civil matter, or also government will can collect genetic material now. The current draft passed by Union Cabinet, which disregards the ethical dilemmas that are attendant and creation of a national DNA database and contrary to established wisdom. It means that the draft which they passed, it is not in right direction. It will conflict. It will have conflicting impact on the established wisdom. Already the people who have thought, who have experienced this collection and all, and the people who tried to use this information, DNA testing, fingerprinting in investigative matter, they already established process will be in danger if this draft is implemented. It is passed in Lok Sabha, but it is not implemented. It has to go to Rajya Sabha, and then they will decide whether it has to be implemented as an act or not. And as we have known about, DNA is infallible. Infallible means it will be uh, it, it could be used to anything. It could be used to help the social cause. Even we can relate DNA profiling as a economical, and we can relate it to criminal justice system also. And we have known about that infringement of civil liberties are passing this DNA bill will infringement of the civil liberties that the society have right now. We will see the reasons how it gonna do that. Indiscriminate collection of DNA, it is one of the thing that it will be done by state on the society, on the people who are living in the democracy. As even we know that the it will cause legitimate trade off means that even if people doesn't want to give, or it will be against their interest, still they have to give their DNA, genetic information, genetic material, or for the testing their body parts. And we know that there are some body parts by which DNA and the genetic material can be collected. The here you can see blood, like blood. From blood also they can collect little genetical part. Hairs, hair follicle is a source of, every part of our body is a source of genetic material because it has a cell. It has a cells means definitely it will have nuclei and nucleic acid. In that nucleic acid there is a DNA present chromosomes, genes, genetic, each and every material is present there, even skin cells of the body. Across the world, we have seen that the DNA evidences in criminal matter, investigative matter, and the have proved very as we have seen, the number of cases have been resolved because of DNA evidence is found there. But in India it is totally different. In India we are using it in a civil matters also. We are collecting genetic material, and according to this DNA bill draft, they are trying to establish a DNA bank which will collect all the data of the people of our country, and they will store it. Whenever it will required, they will give us the data. When did it start? When did it start talking about collection of DNA and all? The Code of Criminal Procedure in 2005, for the first time, they just talked about it. Here you can see in which expressly in 2005 who was the authorizing investigating officer that time. They were authorized to collect the DNA sample from the with the help of medical practitioner. But and as we have seen, government is trying to establish a bank, information bank, DNA storing bank, which will be stored on a number of bases. You can see these three indexes. There are certain three indexes on which bank, a DNA bank, will store all the data who is regarding the suspects. Crimes in index. In crimes in index, this data will be stored regarding the people who have done crime, and the other index is suspect index. In this, those people who have been identified as a suspect, their genetic material will be kept in this part. And the offender index are those indexes, those persons who are habitual of committing anything, any mistake and any mischievous thing. Like you can keep in this index the person who often held with robbery, thieves, and if teasing. These cases could be kept in offender index. Uh, why government is doing this is because it will facilitate identification of a person. It will reduce their time in identifying the accused, and it will save time as well as manpower as well as money. Waste. It will also stop the wastage of money. And identification may relate identification after identification of a person, we can relate this to uh, what could be identification with the with against or with the provisions to criminal investigation. This is one of the thing where identification will help out the investigating officer. Even in judicial proceeding we can see that we can expect that number of judicial matter will be done with this. Even in India, as I have talked recently about, even in civil cases of the has provision new DNA bill has a provision relating provision in parental matter, even relating to pedigree. pedigree, and issues relating to establishment of individual identity. These are the criminal investigation, judicial proceedings, parental disputes, and relating to pedigree. These could be sought out and these could be resolved by using genetic material. It will be a problematic because it will it will in it will be definitely infringement of the privacy of an individual. And as we have seen in Puttaswamy case, Justice Puttaswamy case in 2017, nine constitutional judges bench has already said privacy is a fundamental right of a citizen of a country, in our country. Even in it is inserted in the constitution. The proposed DNA bill is vague, according to some of the experts, who just does not want to reveal the method of collecting a data. It it means that the common people will not know how they have collected their DNA samples from a body, from where they have collected, like from hair or from a skin or from blood, how they collected data. It will not be revealed. This is ostensible, and even a civil dispute, to solve that civil disputes also, it will be our DNA data will be collected, and this is somewhat problematic in our country. Why? Because even if you take an example of a person who is riding bike and uh, he breaks some rules over there, even we can see that for that offense also he has to give his genetic material data to the police. They will collect it, and they will store it somewhere in the bank, and in requirement they will say, and if the same person held with a civil dispute with parental or in a property right, same data could be used against, number of time it could be used, and it is clearly violation of his privacy, violation of his data privacy. Even we have seen that even a person who is refusing, even a person who is refusing even a person who is refusing if suppose if person is refusing it, after drafting, after passing this bill, after enacting this bill in it, and it will be implemented as a law, and after bringing it into the law, people will be compelled, people will be held, people will be forced to give their genetic material. If his individual doesn't want to give his genetic material, in case, the magistrate, district magistrate will order, in case if person is really if judicial process will be getting some help in establishing a person's guilty, to, to magistrate can order or can make him obey the rules, and it will, by all this we can see there is even in a framing this DNA bill, state, they are framing according to the state, like state will have advantage in this bill. A common people cannot do anything in front of a state. If they want to collect it, they will collect it, because these provisions are added into the bill. These are, and we will see in further, we will see infringement of privacy. You can see that bold black letters, uh, this one. um, so we will see how it will infringement our privacy. And after passing this bill, already we discussed, people cannot say, and it can be collected without the consent of a person who is there. Even in a 2012 report filed by a group of experts on a privacy, AP Shah Justice, who has given the task and who has led from the front, and who was against this person, said that the collection of genetic material from any person's body will be violating basic liberties of a person. And according to some of the experts, it is said that government will be compelled, government will be forced by a common citizen to collect the data with the two things, that is, one is principle of necessity and the second one is principle of proportionality. It will not say, it will not be like violating the norms, violating the fundamental right of the people. We move further and we will see the recent evidences where our DNA data has been used as a, in we have seen that in all over the country, not in our country but in whole world, we have seen that the DNA, a collected DNA data will be used in investigating purpose only. But in our Indian scenario, DNA data which was collected on a certain purpose will be used for civil cases, civil disputes. It will be used, and other thing is that even illegally obtained evidence is admissible in court of law. This is only in our Indian scenario. It is not, you cannot illegally obtain somebody's genetical data and somebody's information without the consent of a person. But in Indian scenario, the without the data which was obtained without the consent of a person could be admissible in court of law in our India. It doesn't happen anywhere in the world, but it happens in our country. How great our India is, you can imagine. The draft law does not restrict DNA profiling of a person. The second thing, and if we see to enact the law in its present form, therefore, will only add new menacing weapon to the state's rapidly expanding surveillance. Already, state have number of powers which has given by the authority to them. They can exploit humans. They can exploit individuals, people who are staying on the land, and by enacting this bill, it will add more power to state treasury. And we should not allow such a benefit of science and technology to be privileged over the grave risk in allowing the government untrammeled access to deeply personal and penetrating material. Let's move on to the next article, against the mandate of inclusion. This article is all about transgender bill. We have seen that recently there is a transgender bill has been in 2016 transgender bill, transgender person of protection of rights of transgender person has been passed in 2016, but it is amended and it is presented again in parliament in 2018. With the passage of this bill, we can see that there is no real understanding of a gender and identity and expression in this, because the previous definition of transgender was something different. What we knew, what was the definition previously given by a government? Previously, government said that the person who is neither a man nor a woman will be called as a transgender. But it is totally against the wish of the person who himself wants to declare himself want to declare hmm, as we can see that the NALSA, the you must have known about NALSA. It is National Legal Services Authority versus Union of India in 2014. It was said it is against the self determination of gender. It is right to self determine, which was in 2014. Nalsa has given his verdict, given any surgery or right to self-determination of gender or as a male and female of a transgender without mandate of any medical certificate and sex reassignment surgery. It will not be done by giving any certificate, and it should not be done by a sex reassignment surgery, that is called SRS. And also clearly dictated any insistence for SRS for declaring one's gender is immoral and illegal. Many experts and many people have said that, currently the bill which is passed by the government of India, passed passed by the cabinet ministry cabinet of country, is a regressive bill. The bill does not provide for employment support. The first point we're gonna raise is about employment opportunities to the transgender. Bill itself doesn't represent or doesn't have provision regarding the employment opportunities which will be given as a reservation to the transgender people. And this bill also disregard the guideline and the direction of a court in a NALSA case. NALSA versus Union of India 2014 case we have seen. And with the filing complaints and with the PIL filed by a transgender community, after that the government has to change their definition of transgender. Now in this bill, our definition of transgender will be the person at the birth, the gender which is given at the birth, male and female, it will be called as a trans male and trans women's. And the second point we're gonna discuss, which will show you how regressive this bill is. The third point is bill this bill criminalizes begging. We have seen transgender people, they don't work, they don't have reservation in education, they don't have reservation in employment, they don't work in any government and civil offices. They have left with nothing but the begging. We have seen they beg in trains, they beg in the railway station. Begging is the only source of earning for some of the transgender people. They don't have any subsistence source by which they can earn and they can buy their food. So by criminalizing begging, they are government are being harsh, being discriminative against the transgender people. Even Delhi High Court in case of Harsh Mandar versus Union of India 2018 said that the detaining marginalized individual under the garb of rehabilitation have also been criticized. It has been criticized under the Rehabilitation Act. They are saying that the a person who is transgender should not beg. That's why they criminalized begging. Court, a Delhi court declared Bombay Prevention of Begging Act, Bombay Prevention of Begging Act 1959 as unconstitutional on the grounds that they violate Article 14 and Article 21. Article 14 says equality before the law, and Article 21 says right to life and personal liberty. Both of these articles and both of these fundamental rights are violated by this Bombay Prevention of Begging Act 1959. Move on to the next page and we will see the next point. It fails to extend the protection in regard of sexual assault or rape which happen on them. Why? Because in our Indian Penal Code, only men and women has been described as an entity and perpetrator and victims respectively. There is no mention of transgender people in Indian Penal Code. That's why bill fails to extend the protection. That is why we can say this bill is regressive one. Bill does not grapple with the realization of civil right. Yeah, this bill also does not recognize their civil rights like marriage, civil partnership, adoption, property right. Property right, they doesn't mention that transgender people will have some right in property. These are the some things that we need to replace and we need to amend. We need to tell our government that they need to replace and make it more socially, economically, and politically empowered transgender people. They should make it according to that. Need of the hour is nothing. Need of the hour is nothing but the robust bill and strong anti-discrimination bill. Provision that will remedy an historical injustice faced by the transgender community, which continues to fight for the most basic right even today, should be given. The whole article is on the transgender. Whatever that bill is regressive, we have seen that, and question could be asked: the suffering of the transgender people in India. Thank you so much.